So as I've already indicated, one of the key problems with HMO management is that people think it's just like managing any other property, but it's not. So management of an ordinary family property tends to be reactive in nature. That's not to say bad, but generally speaking, tenants report problems and you deal with them promptly. And provided you do so, that is fine. That is not the case with HMOs because there are the HMO management regulations. And the HMO management regulations make loads and loads of things offences which are not otherwise offences. So for example, disrepair in an HMO is in itself an offence. And those are strict liability offences, so as soon as it occurs, you are committing the offence. And a local authority officer who inspects the property, whether or not you've been told about it, is entitled to and will prosecute you for its condition. Okay? So the difficulty is you tend to find when local authority officers turn up, and the problem you've got, of course, with HMO tenants, you can't rely on them reporting it to you. They might equally well just phone the local authority, environmental health, and say, this is no good. So you can't rely on tenant report. And there tends to be an assumption by local authority officers that what they find on any particular day of the week is the state of affairs all the time, and not just the result of a really, really banging party the night before. And that is a bit of a problem. So your objective is to try and demonstrate that, generally speaking, your property is well managed and anything that happens to be wrong on a specific day is an exceptional scenario which does not warrant prosecution. Or it's an exceptional scenario which justifies what is called a reasonable excuse in law, which is why you're not guilty. Okay, and that can sometimes be quite difficult. So what you really need to make sure you've got is clear evidence of regular visits to the property and strong follow-up of problems. And
how frequently would you have good?
That is an excellent question. It depends. Don't these things always depend? So I tend to recommend these days doing a risk assessment near the start of the tenancy in writing of the tenant and the occupiers. And what you would be considering is the nature of the tenancy, how high risk they are, the type of tenancy you've got. So is it a whole property let or a room by room? Because obviously that affects your ability to access the property. If it's on a room let with a license for the common areas, you can essentially at law just walk into the license of the common areas whenever you want without notice. But obviously you can't barge into people's rooms. And if it's a house let, you of course need to give notice of intention to access. And I would look at the way the tenants are treating it. And then I would decide on an appropriate inspection regime. Now that might range from quarterly in the lowest risk situations, so young professionals who keep the house tidy, down to weekly, high vulnerability tenants on full benefits with significant social problems who are on room lets. It might be appropriate to inspect those properties on a weekly basis. And I've certainly got clients who inspect their properties on a weekly basis.
We have somebody inspect weekly.
Yeah. So it's entirely dependent on people. If you're doing high vulnerability tenants, then absolutely that is the right thing to do. In some cases,